scholar because Shastrajna not only learned, kapata anusara kusala, he must know all the hanky-panky which the parties are capable of. Otherwise, how does he say? Vakta, absolutely dignified. Dachak Prodhana, never lose his temper. Today, unfortunately, sometimes I feel judges losing temper. If you say you behave like this, I lost my temper, that is, it is only then you should not lose your temper. When everyone is behaving all right, if you lose your temper, what to call about you? That's the occasion you should not. And Pruitt also said it in 1945. Judges are more of human, and their patience is often sorely tried by counsel and litigants. But it is to be regretted that judicial temper should even appear to give way, not give way. But of course, parties and counsel who are responsible to bring about the situation have no business to complain. Because justice must not only be done, but must appear to be done. Justice is primordial. If that has to be hold the balance, you have to hold the balance, then we require independent judges. Only if the judges are independent, the institution will be independent. Only if that institution is independent, then the bar will be independent. And only if the bar is independent, the bar and the bench being the two wings of the bird of justice, the bird justice will fly high up in the air. The moment one of these wings falls, the bird will fall down. And if that falls down, democracy is demolished. It is a banyan tree. Because not only the trunk, it goes on living on all the, you alone must have seen in those days, not now, the idea of banyan tree. That is Sanskrit. And why did I say it's a banyan tree? Because I am speaking a little about Sanskrit and Dharma before I come to Dharma, because the function is Samskrita Vaibhava. Therefore, it used to be said, Telliya Alim Sirvarthu Odivirai, Tennir Kayachut, Sirmir Sirainum, Nunide Ayinum, Annal Yanai, Anider Pirabi, Adperum Badayodu, Mandar Kirukka Nilalahume. King with a full army, with all his horses and elephants, can have shade under the tree. That seed is only a very small one. And that word, Samskrita, is maybe one word. From that grows a banyan tree. You can see Dharma, you can see philosophy, you can see debate, you can see law, you can see science, you can see economics, you can see politics. There is nothing under the sun, no subject under the sun, which you can't see in Sanskrit. And that is the greatness of Sanskrit, and that's our heritage, of which we must be proud. Judgment was delivered on Saturday. On Monday night, 8:45, at Delhi, in the residence in which I am, above the second floor in the open terrace, about 30 or 40 monkeys came. Can't imagine so many monkeys, and that too night at 8:45. Therefore, and they were playing, jumping, kicking. The next house construction is going on. They won't kick the tin which is covered throughout to avoid any pollution. There is a drumstick tree in the service lane. They broke almost all the branches of the tree. It's almost a tree now standing with only one or two branches. The hand of God has played. Lord Ram has taken care of it. 69 years he waited for it. From 1950, for 69 years he had waited for it. When he came as avatar, only 14 years of Vanamasa, and in Parnasala life, 14 years. He lived in a Parnasala. Now it is 20 years after the demolition, 29th year. Twice that time he has been in Parnasala. He had waited enough. His patience gave way. He said, enough is enough, a temple shall come. I profusely thank every one of you. I must congratulate Sastra University, Mr. Setu Raman, Mr. Vaidishu and others for the wonderful work they have already done in bringing this university to a position of great reputation. It has started a march and will never look back. The reason is they mix dharma in every aspect of their vocation. G. Ramaswamy was a wonderful lawyer. If you want to have humor in court, that was one person. Nobody can match him. He was a lawyer practicing in Madras. We were very good friends. All of us have got plus points, minus points. But never look at the minus points of others. See the plus points. If you don't have it, emulate it. If there's a minus point, ignore it. When you see yourself, see your minus point so that can you eradicate it. Don't see your plus point. Pasyati pareshu doshan, asatopi, satopi naiva gunan, viparitamitam swakarma bihi, is what the Sastra say. So G. Ramaswamy and his junior were returning home after going somewhere. A very heavy case, very big rich client, a very good harvest he was having. So he was returning. The car failed on the way, there was a puncture. He had given a time for the client. They must be there in time for the client. So they got down. No, we have to go in time. What do we do, sir? Luckily an auto was passing thereby. They called the auto, they got into it. They went and got down in their house. The client was also getting down from a first class imported Benz car or some car. The junior told Ramaswamy, sir, if before such a client, if you come and get down from an auto rickshaw, what will he think about you? He said, don't worry, by the time the case is over, we will come in that car, he will come in the auto. Pepinian, lot of pressure was sought to be exercised, imperial pressure on Pepinian, one of the jurists. They were called prudentes. He declined. The message went from the royal quarters. Do you know the price you have to pay? He said, I know the price, but I can't sell my heritage for a mess of pottage. Take the price. And his head was chopped off. Please remember. Therefore, he is still remembered, till today remembered. Justice Khanna is still remembered because you stood up. Why they are remembered? Ekayeva sugrit dharmo nidane apyanuyati sarirena samam nasam sarvam anyatyu gacchati. Everything will perish. But you have walked on the path of dharma, it is immortal. This has been our concept. Dharmo rachyati rachitaha, dharmo hantyataha. Yato dharmas tato jataha is the Supreme Court. Satyam eva jayate is the High Court. Satyam and dharma, both are two eyes. There is no difference between them. Both are same. But conceptually it has been explained a lot, which I can't do now. But both are eyes. Those two eyes alone give the vision of dharma. Not only those two eyes. Modiyilar kedu mudanul theriyum, vidiyilar kedu vilakku. You require language. Without language, you can't know Sastras. Sastra is not merely in Sanskrit. It is in Sanskrit, it is in Gujarati, it is in Bengali. We had a Kashmir Saivism, my lord may know it. Kashmir Saivism, somebody when I went to Kashmir for a case, I was fascinated with the book Saivism, which is Kashmir Saivism. We must learn everything. You may use them or not use them. The profundity of the knowledge will alone help. Only four who are role models. Bharadwaja for his knowledge, Baraspati for his wisdom, Vishwamitra for his activism, and Vidura for his needy. If that needy comes to be established, law will take care of itself. Thank you very much.
Good evening, ladies and gentlemen. It gives me immense pleasure in welcoming you all to this year's edition of Logical Connect with an enigmatic panel of some of the most distinguished and knowledgeable minds from the legal fraternity, comprising individuals who have not only made their mark in the courtroom but have also shaped legal discourse in profound ways. I'm Swaminathan Krishnan, a final year law student at School of Law, Shastra University, and it is my honor to take you through today's panel discussion on the topic Concurrent List Constitutionalism. Before we commence today's event, we shall invoke the blessings of the Almighty by an invocation prayer, and I request all of you to kindly remain seated in devotional silence.
आत्मवदेव परानपिपश्यत आत्मवदेव परानपिपश्यत युद्धं त्यजत स्पर्धां त्यजत युद्धं त्यजत स्पर्धां त्यजत त्यजत परेश्वरक्रममाक्रमणम् त्यजत परेश्वरक्रममाक्रमणम् मैत्री भजत अखिल हृजेते मैत्री भजत अखिल हृजेते जननी पृथिवी कामदुघाते जननी पृथ्वी कामदुघाते जनको देवः सकल गजालो जनको देवः सकल गजालो दाम्यतद्रत दयध्वं जनता दाम्यतद्रत दयध्वं जनता श्रेयो भूयात् सकल जना श्रेयो भूयात् सकल जनानां श्रेयो भूयात् सकल जनानां श्रेयो भूयात् सकल जनानां श्रेयो भूयात् सकल जनानां.
I now request our respected Vice Chancellor, Dr. S. Vaidya Subramaniam, to welcome the gathering.
Distinguished speakers for this edition of Lawgical Connect, distinguished members from both the bench and the bar, a very intellectual audience from the fertile soil of Chennai, other guests, friends from the print and the electronic media. I am extremely happy to welcome all of you for yet another edition of the most awaited flagship event of the School of Law Shastra University's Lawgical Connect. Whenever we organize an event of this type, especially the Lawgical Connect, Chennai never fails to throw up an audience that comes here because they like the topic, they like the speakers, and they like the way in which the proceedings of Lawgical Connect happen. And this we have been seeing right from the first edition of Lawgical Connect happening in Chennai. So it is an event of this type that seeds intellectualism in the fertile soil of Chennai, which later sprouts because of the carefully chosen speakers for each of the Lawgical Connect session. And for some faces that appear familiar, please recall the Lawgical Connect first edition when we had it in 2013, and many did not even believe that it was possible for a fledgling law school to bring on the same stage eminent jurists like Senior Advocate Sri K. Parasaran, Senior Advocate Mr. Ram Jetmalni, Senior Advocate Mr. Soli Sorabji, and Senior Advocate Mr. Anil Divan. All four of them moderated by another equally distinguished intellectual, Mr. S. Gurumurthy. So that day was the first day that we saw more than 300 years of combined legal wisdom packed in one stage. And we have somehow managed to maintain the same continuum by inviting some of the best minds speaking on relevant topic. The reason that I am saying that it is relevant because every time we conduct the Lawgical Connect, which happens once in 2 years, as a fallout to that Lawgical Connect, there is something that gets churned and happens in real life. Remember in 2013 it was on the NJAC. At that time it was at the proposal stage, and then it came as a bill which got struck down later. And then the second edition we saw an issue that discussed with various personal laws, which included the UCC, which included the Hindu law, which included other laws that was particular to a personal ecosystem. And immediately we saw a lot of active litigation in those areas in 2015. Then we had a session on black money, and then came PMLA. So that time also we found that there was something that was happening after Lawgical Connect. And the next edition we were actually thinking of what topic we could have. Then we had a session on constitutionalism, and Senior Brigade Mr. Arvind Dattar will recall he was a speaker in that Lawgical Connect, because that the topic of the season those time was what is constitutionalism, because everybody started talking about constitutionalism and it saw different varieties. Somebody said constitutional morality, then constitutional nationalism, which later we saw Article 370 and other related issues being litigated in the Supreme Court, bordering on the issue of constitutionalism, which had different derivatives when it comes to understanding it from a terminological perspective. Then we had also a term that is called constitutional silence. I don't know where it got manufactured, but then very recently you saw, the Article 200 interpreting constitutional silence itself in a different issue. The last Lawgical Connect we had on UCC, which is again a subject matter of discussion in different states as well as in the union government. So to cut the long story short, Lawgical Connect has been a platform where we discuss on topics of contemporary relevance. And this year we couldn't think of anything better than to choose a topic that is related to the concurrent list, and we named it as concurrent list constitutionalism, and how it impacts the center-state relationship. And when we started planning for this event, we had different names popping up, but clearly the names that stood out who could enlighten an audience of this time are the names that we successfully managed to get for this evening's event. So ladies and gentlemen, please put your hands together to welcome Mr. C.S. Vaidyanathan, Mr. Arvind Dattar, Professor Argo Sen-Gupta. And I'm extremely happy that one of my star graduates and a very successful practicing advocate, Amrit Bhargav, is moderating this session now. So with these few words, I'm extremely happy that all of you agreed to accept my invitation to be a part of this panel discussion. And I also have a request. In fact, when we prepared the agenda for this event, all the speakers unanimously said we'll talk less and we want more questions from the audience. So after the opening remarks from each of the speakers, don't think that the event is over. Typically, when the main speaker speaks, the main opening remarks are over, somebody will be a little impatient to leave the audience, but then the maximum action on a tempestuous topic like this will happen only during the question and answer session. So I request all of you to please stay back till the end of this event. So once again, I welcome all of you on behalf of Sastra. Thank you very much.
Thank you, sir. I now request our Vice Chancellor to felicitate the distinguished panelists, starting with Senior Advocate Sri C.S. Vaidyanathan. I request the Vice Chancellor to felicitate Senior Advocate Sri Arvind Dattar. I now request Dr. Vaidya Subramaniam to felicitate R.K. Sengupta, the Founder Director of Vidhi Center for Legal Policy. And finally, Advocate Sri Amrit Bhargav, the moderator for today's event. Thank you, sir. In the architecture of the Indian Constitution, few elements embody the tension between unity and diversity as vividly as the concurrent list. It is not merely a catalogue of subjects. It is a constitutional conversation between the Union and the states unfolding every day in our legislative and judicial arenas. Today, we engage with the concept of concurrent list constitutionalism, a pivotal yet under-examined and nuanced framework within India's federal structure. Situated at the intersection of union and state legislative competency, the concurrent list raises fundamental questions about the distribution and exercise of powers in a quasi-federal system. When both levels of government legislate on overlapping subjects, whose authority prevails and at what cost to cooperative federalism? Does this shared jurisdiction promote synergy or sow conflict? And most crucially, in an evolving polity, is the concurrent list an instrument of balance or a source of constitutional ambiguity? Keeping these questions in mind for our panel discussion, I now invite our proud alumnus, a research scholar and an advocate practicing in the Honorable Madras High Court, Sri Amrit Bhargav, to moderate and to take us through the discussion. Please, sir.
Thank you, Swami, and good evening. It is with some trepidation that I stand in the midst of such a distinguished panel of speakers for Lawgical Connect 2025. It is not just the panel that is daunting, but the subject of today's evening that is as evocative and as endless as it is. When we spoke about what topic has to be chosen for this year's Lawgical Connect, it came to concurrent list constitutionalism with the sub-theme as impact on the center-state relationship. Broad enough as the canvas has been, there is so much that can be spoken about on this subject alone. When India became a republic in 1950, it had to grapple with issues that were unique yet typical for a country of its size and diversity. The distribution and division of powers between the union governments and its states. Whilst the country was named India, that is Bharat, its status as a union, contrary to being named as a federation, speaks of the constitutional intentions and visions that have informed the narrative of federalism in India. The Government of India Act, both in 1915 and 1935, already dealt with the distribution of powers conundrum, and it is well known that the federal and provincial lists found their spot in the 1935 enactment. In an atmosphere where nomenclature and public vantage points become occasions to revisit India's federal story, this year's edition of Lawgical Connect 2025 at Sastra deemed university provides just that. Federalism is not just a byword for an administrative model, but has been realized through the text and practice of constitutionalism in India. Constitutionally embedded at multiple levels, the relations between the union and the states punctuate the daily governance and running of the institutional design. We are aware that Part 11 of the Constitution deals with this subject in all its detail. The legislative relations on the one hand, where the union and state are covered through Articles 245 and 246, which is similar to Section 100 of the Government of India Act 1935 and Article 254 in this Constitution. And in terms of its administrative relations, the Office of the Governors for the states and its relevance in the state machinery provide the overarching status for the union in respect of its states. In fact, when the Constitution came, one of the biggest criticisms was that it was a highly centralized state. In terms of legislative power sharing, we are aware that Article 246 confers the legislative powers on the Parliament and state legislatures. Then we have the 7th schedule with list 1, which is the union list, the state list, the concurrent list, and the residuary powers. So this is something that we have known. Article 246A came where the goods and services tax came, and then provisions that deal with repugnancy, the powers of Parliament to deal with subjects which cover national interests, powers during emergency, and all that which is covered in the relevant portions. It is puzzling that for all the highfalutin emphasis on the constitutional measures of centralizing tendency, India has created and added more states and union territories since 1950, only demonstrating a powerful understanding that political sovereignty means territorial creation and changes. In fact, federalism has not just found its expression through the constitutional text, but the daily meanings of lived experiences under a written constitution that is 75 years old. Having a written constitution that has withstood and has shown resilience is itself a great achievement for a republic of our kind, with such interpretations by the highest court from time to time, which recently found explication in the 9 judges bench on the mineral rights last year, where senior advocate Datta sir also appeared. And in fact, in Justice Chandrachud's opinion, there is a conspectus of the various past and contemporary flashes of this subject, especially recalling that famous judgment dealing with the Bihar Finance Act of 1981 on Hoches Pharmaceuticals, which neatly summarize the principles relating to the legislative and administrative relations. This is there in the judgments, and I'm not getting into it in detail. And we have Justice B.V. Nagaratna's opinion, where there is a sentence that appears, which I'm sure our panel will find interesting, where it is said, and I quote, that the question of invasion into another legislative territory has to be determined by substance and not by degree. Constitutionally enriched by the pronouncements, the politics that surround federalism have also to be discussed, which is as old as the constitution itself. Pausing for a moment, Lawgical Connect seeks to reflect on the non-legal events that have shaped the federal landscape. The 1950s, which saw the tumult and tide of lofty constitutionalism, the 60s and 70s taking India into the debate between parliamentary sovereignty and judicial independence, and the end of the emergency that heralded the start of coalition politics that eventually reached a climax somewhere in the close of the 90s. With such an accentuated evolution, constitutionalism has become the balancing factor for union-state relations. It's also interesting that the 80s, we had the report of Justice Ranjit Singh Sarkaria, which said center-state relations. And then when the National Commission to review the working of the Constitution came with Justice Venkatachalaya, this phrase used is union-state relations. Federalism has also been impacted by the economic tryst with legalities, and in fact the Vidhi Center's 2015 report on cooperative federalism on the 4 planks of the unity and integrity of the nation, ideals and institutions, and the operation of the economic system and public trust deal with it in detail. And we have also found that union-state relations have a peculiar typology to it. When the same party governs at the union and state, when the parties are different, and then in the middle we have the equation that gets a little more interesting with the institution of the civil services at the policy level, when we find a lot of people talking of policy, and it's all getting decided in Delhi. Delhi is India, India is Delhi. This is something that we have kept hearing. So the makers of the Constitution seem to have very deliberate designs when they use the phrases subject to the provisions of any law made by Parliament, subject to the provisions of the entries, subject to any limitations imposed by Parliament other than, not including. All this affirm the need that there are some dominant domains of law in the respective spheres of constitutional activity. So ultimately, what has India now come to be? And is it, as K.C. Ware said years ago, that it's a quasi-federal model or a federal state with a unitary bias? We have Lloyd Rudolph and Suzanne Rudolph, distinguished political scientists, writing in 2010 that India is a striking exemplar of the non-nation state rule. It continued along the road Western Europe turned away from when it abandoned the Holy Roman Empire. India's historic concepts of stateness and collective representations of the political universe featured an imperial state. On the one hand, it aggregated diverse territorial, cultural, and functional communities. On the other hand, it featured a symbolic and institutional domain. So, at this tight intersection of federalism, constitutionalism, parliamentary law, the judgments, and the politics that surrounds these conceptual understandings, we have the program today. And now we should start with each of our speakers. And our speakers are well known, there's no need for introduction. Senior Advocate Sri C.S. Vaidyanathan, a distinguished member of the Supreme Court Bar, a very well-known benefactor of Sastra deemed university, was instituted an endowment in 2021 for the benefit of the law school. Senior Advocate Mr. Arvind Dattar, who has also visited the Tanjavur campus in 2016 and has enriched many platforms for this university, and has recently argued the 9 judges bench last year, which dealt with federalism in many respects on royalty and tax. Dr. Orgos and Gupta, which I'm sure is the beginning of many visits to this campus, the founder and director of the Vidhi Center for Legal Policy. The pioneering research that Vidhi has done has shown a lot of way in cooperative federalism, and the report Constitutional Cobwebs, which gave an ideal 7 schedule, has also given a lot of space for debate. So with that, may I invite Senior Advocate C.S. Vaidyanathan to share his views.
Namaskaram. Good evening to all. I have a very distinguished panel of colleagues in the profession who are specialists in certain fields. I'm more of a generalist. Let me give a perspective which is divorced from politics of the day and more focused on the legal and constitutional historical perspective. When the constitution makers were contemplating how the powers are to be exercised in a country which was getting free from colonial rule, they had different models. Remember, large parts of the country were separate kingdoms, Maharajas, provinces. They were all brought together. There was, of course, Madras Presidency, Bombay Presidency, Calcutta Presidency, etc., which had large areas. The colonial masters parted with some powers to the local legislature. So one of the things that came up for consideration was, how are we going to distribute the powers? If we are going to have small provinces for the sake of convenience of administration, what kind of powers will we give them? Is it going to be more centralized? So, after examining various models, the constitution makers in their wisdom, and please bear in mind, constitution makers were not so much driven by party politics when they made the constitution. Parties may come and go, but at that time, they were all having a united purpose of having a free country providing food, education, social security, etc. to the people, and ensuring also at the same time security of the country, communications, etc. These are broad common purposes with which they shape the Constitution. 75 years have passed since the Constitution came into force. And look at our neighbors, and then we can be proud that the Constitution makers devised a Constitution which has withstood 75 years and which will stand for several more years. Nothing is perfect. Experience teaches us we can learn, we can amend. In fact, in the context of today's subject, there were 3 major amendments to the Constitution. One was the 42nd Amendment during the emergency, when a number of subjects from the state list were brought into the concurrent list so that the center could exercise more power. Some were brought back when in the 44th Amendment, when the Janata came to power. We had a second major set of amendment which unfortunately is not being talked about much, nor is it being implemented much. That is the 73rd Amendment of the Constitution, which brought in Chapter 9 and 9 capital A, seeking to devolve more powers to panchayats and municipalities. I think this was a very far-sighted amendment, which unfortunately, but for the state of Kerala, other states, even though it is well within their powers, they have not chosen to implement and give powers to the panchayats and municipalities. I was reading yesterday's paper. Karnataka wants to have a greater Bangalore Administration Act or some such thing, which will perhaps take away powers from the Bangalore Municipal Corporation and vest it in some other authority. So far from conferring powers on the municipal corporations and panchayats, we are depriving them of that. The third major amendment, about which Mr. Datar, I think, will be speaking, is the 101st Amendment. Very statesmanly move by all parties, which unanimously voted for GST. They set aside the party differences and voted for it in good faith. Whether that faith has been kept in the last 10 years is a matter of debate. When we talk of lists, legislative lists and conferment of powers, please keep in mind it is not mere conferment of powers but conferment of duties on the government. Parties don't get elected for exercising power alone, they have a duty to the citizen. That's their first responsibility. But for discharging the duty, they must have the capability. they must have the fiscal powers, they must have the funds. What has unfortunately happened is the most vital aspects which concern the common man in regard to his everyday life, like education, health, family welfare, security, public transport, water, sanitation, etc. These are all states' responsibilities. Almost 60% of the expenditure is to be incurred for these aspects, while the states have the power to raise finance only to the extent of 40%. Therefore, the rest they depend on the center. This is a very, very important aspect which needs to be kept in mind by all of us. About 90 lakh crores is the governmental expenditure of the central government and state governments put together. About 50 lakh crores is spent, this year's budget is a little in excess of 50 lakh crores of the center. And about 40 lakh crores is spent by the states. And about 25 lakh crores out of this is on social services, which concern the common man, of which about 8 lakh crores is for education and about 6 lakh crores for health. Now, there is a kind of imbalance. When GST was brought in, nobody anticipated the kind of surcharges and cess that are being levied. Huge amounts are being collected. Now, education is in the concurrent list. Health is in the state subject. Huge amounts are being expended by the center on these. Huge amounts are being collected by way of education cess. Though today, just look at the kind of country that we have. There are almost 1 crore schools in the country. There are about 14 to 15 lakh teachers employed in those schools. About 25 crores of students in schools. Now, how does the man in the central government work out plan in regard to these schools? Why should even the person sitting in the secretariat in Chennai think about this? Why have we not given the functions to panchayats and municipalities? There are about 6 lakh villages in the country. And as I said, if there are about 14 lakh schools, each village will be having at least 1 school, hopefully, or more. I took account of the cities, urban metropolitan areas, National Capital Region, Greater Bombay region, Chennai, etc. These 6-7 cities. Total number of schools in these is more than 1 lakh in just these 6-7 metropolitan areas. Now, why should the panchayats and municipalities not administer? This is one of the aspects that I want you to consider, because when we talk about power being exercised under the legislative list, we forget there are lists 11 and 12. We talk only about the 7th schedule to the Constitution and list 1, 2 and 3. We seem to have forgotten the existence of 11th schedule and 12th schedule, which were brought in under the 73rd Amendment, along with Part 9 and 9 capital A. The second that I want to highlight as an issue is that there is a need, after 75 years of working the Constitution, to examine whether more powers need to be given to the states in regard to some of these aspects which concern the day-to-day life of the people, and whether thereafter the state should not divest themselves of those powers and give it to the panchayats and municipalities. One of the other things that I want to highlight is with the huge revenue raising powers that the central government has, one expected that there will be a fair distribution as per the Finance Commission. But what has happened is that the surcharges and cesses which are being collected are not subject to distribution as per the Finance Commission's recommendation. Now what happens? It is not as if the central government is keeping it for themselves. Central government has its needs, including defense, various other things, telecommunication, highways, etc. But Parliament, while making appropriations, sets apart huge funds in regard to areas which fall within the state list and concurrent list. Part of it through central schemes, centrally sponsored schemes. Part of it through central sector schemes. Part of it through the distribution of finances as per the Finance Commission. There is a fourth part, which is the discretionary grants. Now, this is where you'll find this morning's newspaper said 2,500 crores given for rural development in Bihar before the election. Now, this is a kind of thing, it's time that we review this kind of power, and discretionary grants should, as far as possible, be done away with, and it should be governed by a formula fixed by the Finance Commission. Ultimately, the state and the center will have to work together, not just the state and center, but also the municipality and panchayat administration for the welfare of the people. Therefore, there should be a greater understanding, greater cooperation, greater consultation and consensus. In fact, look at the topics heading today, concurrent list, concurrent. exercised by two different authorities, and it also can mean concurrence. We have more conflict than concurrence. What is needed is concurrence for the benefit of the people. I want to leave just one thought, and then I think I've taken more than enough of my time. There are areas where states, even today, have the powers which they are not exercising. Like, for example, take even the civil procedure or criminal procedure. Central laws have been made, but nothing prevents the states from making laws which are more suited to their areas. And if they feel that they can take steps which will perhaps bring justice home to the person who is crying for justice earlier, faster, every state must make attempt to do that, and I don't think Central is going to stop. I'm sure if a law is made, it will be assented to. Thank you.
Thank you, sir, for delineating the contours of what is operational federalism in the Indian context with its constitutional implications and reminding us of the salience of the 11th and 12th schedules. For our next speaker, we have Dr. Orgos N. Gupta, the founder director of the Vidhi Center for Legal Policy. May I request him to air his views?
Good evening to everyone. First of all, thank you very much to Dr. Vaidya Subramanian and Amrit and everyone at Sastra for inviting me here today and being part of such an august panel. I'll start where Mr. Vaidyanathan left off, is that the topic for today is about concurrent list constitutionalism, but implicit in this topic is this idea of conflict. The reason why we are debating it, and the subtitle also makes it clear, that there is some kind of adverse impact that this has on center-state relations. And I'd just like to put this in perspective that of course in India with the state and the center we always fight, but at this point of time where of course we are having such bitter fights, there is a larger issue where we have been attacked in a dastardly terrorist attack, and this is actually a time for great unity. So this, we might have our conflicts internally and those conflicts should continue, but overall I think we should keep in perspective that this is a time when we are under some external threat, and so there needs to be great unity, and I want to use that to set this in context. I'm going to talk on this topic in two parts. First, I'm going to briefly delve into this question on concurrent list constitutionalism and touch on one point that Mr. Vaidyanathan made about sharing of center-state relations. And then in the second part of my lecture, as in given the fact that Professor Vaidya Subramanian used the term tempestuous, I think it would be remiss if I didn't speak about the role of the governor in the constitutional scheme, because that is what has the biggest impact on center-state relations today. So I'm going to deal with that question constitutionally. First, on the very interesting point on discretionary grants that Mr. Vaidyanathan made, when we were working with the 14th Finance Commission under Dr. Y.V. Reddy, there were three very interesting legal opinions that we saw that were given to the 9th Finance Commission, which had been headed by N.K.P. Salve. And these three legal opinions were given by persons no less than Nani Palkhiwala and K.K. Venugopal. And there was a third legal opinion by a tax law expert. And all of them came to the same conclusion, which is that discretionary grants, as the Planning Commission at that time used to give under Article 282, was completely unconstitutional. There is no basis in the Constitution for the Planning Commission to be giving these discretionary grants. So actually what we have is a completely skewed system where the constitution actually sees division through a formula that is going to be devised by the Finance Commission under Article 270, read with 280. But in practice what happens, and despite the fact that the Planning Commission has gone, the fact is, as Mr. Vaidyanathan pointed out, discretionary grants still continue. So I think there is a larger structural issue in terms of center-state fiscal relationship sharing. I think that structural issue can also be seen in the concurrent list. Amrit referred to a report that we had done on cleaning constitutional cobwebs. It is our view that the 7th schedule of the constitution requires a review. Like all good things requires a review. This is not a party political issue. And there are two specific reasons as to why this is so. The first is that the idea behind the concurrent list, in addition to a union list and a state list, was that so that we could pretty much exhaustively try to cover all aspects on which legislation could happen. But what has happened over a period of 75 years is that newer subjects have come up. Today we are legislating on competition law, we are legislating on data protection, but these are not, we are legislating on artificial intelligence, but these are not matters that find place in the constitution, and obviously because they were not concepts at that point of time. So what has happened is that there is an increasing reliance on entry 97 of list 1, which is the residuary entry. So while the constitution has entries such as lighthouses and Borstal schools and court of wards, which are not concepts that exist anymore, we don't have any entries on artificial intelligence, we don't have any entries on digital competition and so on and so forth. So one is it needs a review in order to be updated. The second is that we need to think about the third tier more seriously. As I've said in other lectures, that actually the third tier of government is a 2.5 tier, because we went some way with the 73rd and 74th amendment but didn't go the whole way. We need to find a way of now bringing in the third tier within the 7th schedule itself. We need to see what functions can be done by the third tier of government, because at the end of the day, what are these lists for? These lists are for the citizen, and so for the citizen cannot be running from pillar to post as to whether this is something that is done by the Greater Chennai Municipal Corporation or his MLA or his MP sitting in Delhi. As far as the citizen is concerned, there are some basic functions like roads and drainage which has to be done by the municipal corporation. There are some functions in relation to, say, the state capital and transport within a state which needs to be done by the state. And there are some larger national issues like the defense of India and foreign affairs which has to be done by the union, and his representative will speak for him or her in the union. So I think that there needs to be a stronger articulation of what that role of the third tier in our concurrent list needs to be. So as a question to the whole audience, I think, can we think of a concurrent list which is not just 2 tiers of government but 3? And I think we can discuss that later. But as I said in my introductions, in Chennai today, a seminar on center-state relations has only one elephant in the room, and that is the role of the governor. He may not be physically be here with us today, but his presence is looming large. And I don't propose to discuss Governor Ravi's actions. This is a matter on which the Supreme Court has given a conclusive judgment, and we can have a discussion on the judgment itself in the Q&A if the audience so wishes. But one thing is clear from the text of the Constitution, and it didn't really require a 450-page judgment from the Supreme Court to make that clear, that the governor is a figurehead in the constitutional scheme. I think that we need not labor this point too much, that the governor is meant to be a figurehead. In scholarly literature, except for former Chief Justice of the Calcutta High Court, P.V. Mukherjee, and a former professor of mine at the National Law School, Professor T. Devidas, no one has seriously argued that the president and the governor have any role other than a merely titular one. But despite that being kind of the clear position, we have governors who are sitting on bills, dissolving legislatures, acting contrary to the aid and advice of elected governments. Governor Ravi is not the first. He certainly won't be the last, as in he comes in a long line of governors, as in this, who have done this. So the question that interests me as a scholar is, why does this happen? And I think for that we have to go back a little bit in history to the Government of India Act, which Amrit briefly mentioned. And there is a deep historical reason as to why governors behave like this, and I think governors have internalized this aspect. And for that we have to go back to the Simon Commission. We remember the Simon Commission which came to India in 1930, and in my book I have dealt with this issue, so I'm just going to read a very short paragraph. That the Simon Commission in its report in 1930 had recommended that there be responsible self-government in provinces. This was the first time that the British recommended that the provinces have some level of responsible self-government. But it was very quick to add that the linchpin of provincial governance would continue to be the unelected governor. Governors would be assisted in their task by a cabinet comprising a few elected ministers and some nominated persons, all of whom the governor could select. Even then, the Simon Commission felt it would be wise to reserve further power for governors during emergencies, and they could take over the entire reins of government. When government could not be carried out according to the law, presumably owing to riots, disturbances or revolts, the governor could take all power of the state. This John Simon and his colleagues wrote, and I quote, is no denial of self-government. It is the ultimate resource if self-government is repudiated. Now this was the idea that the governor is a safety valve. We remember that the British had set up the Congress as a supposed safety valve for Indian politics, and the British used the same idea of the governor as a safety valve in our constitutional framework. So the legal expression of this came in section 93 of the Government of India Act 1935. This is the immediate precursor of Article 356 of the Constitution, which we know as President's Rule. Now, basically, as we know that under section 93 of the Government of India Act, the governor can take over all the powers that belong to elected government in the provinces. So the Government of India Act for the first time had led to elections in states, and there were 7 states in which the Congress won, and there were 2 states in which there was a coalition government. But the governor continued to hold these emergency powers. But now in 1939 a situation arose. It was the war, and the Congress ministries resigned in protest that the British had enlisted India in the war without having consulted it. So now there was no government in 7 provinces. So here actually it's interesting what the colonial administrators had to say when they had to proclaim emergency for the first time under section 93 of the Government of India Act. And for the British, the power to proclaim an emergency was actually never really about a safety valve. That was only the pretext. It neatly fitted into a fundamental belief of the superiority of the expert colonial administrator over the untrained Indian legislator. The question of representative government in India, Lord Macaulay had long ago said, was utterly out of the question. And now in 1939, nearly a century later, this primitive belief that Indians were not good for self-government found a slightly more sophisticated expression in the governor's emergency powers. The Secretary of State in the UK, Leo Amery, summed it up, and he said that, and I quote, this constitution, that is the Government of India Act 1935, would allow Indians to rule the provinces as long as they do it properly, and leave the governors absolutely free to take over the whole or any part of the administration themselves should the machine not function properly, unquote. So basically the British were of the view that Indians could rule themselves, but only if they could do it properly. Now this was a belief that was internalized by the Government of India in independent India. So in Tamil Nadu, Tamils could rule if they could do it properly. In Bengal, Bengalis could rule if they do it properly. And first in Kerala, Malayalis could rule if they could do it properly. And if they couldn't, which was when the union government felt that they couldn't, then President's rule would be declared. Now this is, and while the position of the constitution may be clear, that the governor has very limited powers, now this is a deeper trend that exists in Indian constitutional law. And this actually in a circuitous way is related to the terror attack in Pahalgam, because this is the overhang of the Pakistan question in Indian constitutional law. Now all of you will remember that the cabinet mission plan in 1946 had recommended that there be a very weak union, and they had recommended 3 groups of provinces. Group A, which would be the Hindu majority Congress ruled states, Group B, which would be the states that are now in Pakistan, and Group C, which is Bengal and Assam. So the idea was that the union would only have foreign affairs, defense and communications broadly, and rest of the power, including residuary power, would entirely be with the states. And on that, it was on that basis that the Constituent Assembly started functioning, that they would draw up a weak union. So in fact, there was a committee called the Union Powers Committee. That was the committee that had 11 lawyers, all the major stalwart lawyers of the constitution framing time were all there as part of the committee, and they produced a very, very short report. They were very unhappy with this situation, but they produced a very short report saying that yes, there will be a center with a union with limited powers, and the states would have all the major powers over day-to-day lives of people, and everything except these 3 powers that the center had. Now, as we all know, the cabinet mission plan fell through, and the Constituent Assembly was not functioning. The Muslim League had refused to participate, and on 21st of July 1947, Mountbatten announced that there would be 2 countries, India and Pakistan, and so the Pakistanis went out of the Constituent Assembly. The moment Pakistan went out of the Constituent Assembly, we trashed the first report of the Union Powers Committee, and we, in a second report of the Union Powers Committee, the committee unilaterally, unanimously said that India would now have a strong union. I mean, that was made extremely clear in that report of the Union Powers Committee, and there were very strong sentiments. And some of the strongest sentiments actually came from people who were not Delhi politicians. T.T. Krishnamachari has said very famously that there should be significant emergency powers that should lie with the union government. B.R. Ambedkar was, despite the fact that B.R. Ambedkar had great difficulties with overpowering governments, said that if given a choice between an overweening central government and a corrupt state one, he would choose the former. So it was quite clear from the framers of the constitution that there was a strong preference to a strong union, and the reason for that was that there was a worry that there would be secessionist tendencies in India, just like it had happened with Pakistan. So this is why that despite the text of the constitution limiting the role of the governor, both under Article 356, which I have discussed, as well as Article 200, which was the subject matter of the judgment of the Supreme Court in the case of the state of Tamil Nadu, this train of thought continues. So this is essentially the ghost of Pakistan that overhangs our constitutional framework. The ultimate irony of this is that section 93 of the Government of India Act 1935, which was this provision to declare emergency and to give sweeping powers to the union. When the British were leaving India, there was a provisional order to adapt the provisions of the Government of India as a transitory measure before the constitution could come into force. When the British were leaving India, they had actually deleted this provision. They felt that once India was independent, it would no longer need a strong union government that could take over the powers of a state. A better balance could be found. But the framers of the constitution, in their wisdom, decided that we do need these powers. So we can agree with Governor Ravi's actions or we can disagree with him. I am not in any way justifying his actions. As a matter of constitutional law, I have written that his actions were wrong. And I think and the Supreme Court is largely right in terms of its judgment. But there is a history to why governors behave in such a manner. And that history is because there is an underlying strain in Indian constitutional law of strong union over a state government. And I think this is not an aberration. It is a matter of constitutional design. So when we are looking at center-state relations in this day and age, I think it is critical for us to understand that constitutional design of a strong center, see how much in 75 years we need to modulate that, and ultimately remember that it is in the interest of the people that both the union, the state and the panchayat and local governments serve. So while we can have disagreements at a meta level in terms of whether the last word should be with the governor or should be with the state, it should not come at the cost of governance for the common Indian. Unfortunately, we are leading to a situation where it is, and I think this seminar comes at a critical time where we can again discuss as to whether India needs a new constitutional compact between union and state. Thanks very much.
Thank you, Dr. Orgo, for taking us on that constitutional trail of the 20th century. And it was almost as if we had a broad survey of B. Shivarau's book. May I now invite Senior Advocate Arvind Dattar to share his views.
Good evening, everybody. Thanks to Sastra for inviting me for the second time to speak at Lawgical Connect. I am particularly happy that I'm speaking to a very distinguished audience. I see Justice Nagamuthu here, Justice Prakash, Justice Vaidyanathan. So many of the eminent lawyers are here, my friends. I can't name everybody, pardon me. But it is a pleasure to speak today. As my friend Orgo rightly pointed out, that the unfortunate attack at Pahalgam perhaps underscores more than anything else to forget about the constitution, forget about everything, but always think in terms of a united India. In a sense, the constitution is like a joint family in that sense. You have the main karta, which is the union, and you have all the states which are like the co-partners. And as lawyers, we know what happens when there is no unity within the family. So, apart from constitutional law, it's a deep point to introspect, and we should now set aside all our individual differences. The governor should not be forces to destabilize the government or to create problems in the government, but all of us must think of working very, very united. As an African proverb says that if there is no enemy within, we need not fear any enemy without. That is the great African proverb. Now, my talk on federalism is mainly confined to the fiscal aspects, the tax aspects of federalism, which is a subject I know to a certain extent. As Mr. Vaidyanathan rightly pointed out, there is a sense of disproportionate skewness towards the center as against the state, which unfortunately is growing larger and larger. If you take the constitution, take the union list, entry 82 to 98B deals with powers of union taxation. It starts with 82 is tax on income, 83 is customs, 84 is excise and so on. And 97 of course is the omnibus residuary entry, and that is the place where different taxes have seen their genesis. We had a question of where is the provision for gift tax. Supreme Court said gift tax is not there, we can trace it to entry 97. Where is service tax? No entry for service tax, no problem. It is in entry 97. So that gave union large powers of taxation over the years. In the state you have entry 46, it starts with agricultural tax on agricultural income and goes on to entry 62, 63, 64 I think of the state list for taxes. It is also important that the division of powers is largely followed what was done in the Government of India Act. The powers of taxation are virtually the same. Apart from the amendments which Mr. Vaidyanathan mentioned, the other very important amendment, the fourth important amendment, is the 7th amendment, which provided for interstate taxation. And talking of fiscal federalism or contested federalism, when each state had the power to levy their own taxes, you started leading to a case of multiple taxation, where the state where the sale started would tax it, the state where the goods were delivered to tax it, the states through which the goods passed would tax it, and ultimately you led to the Bengal immunity case, and finally Parliament settled the whole thing in 1956 by the Seventh Amendment, which enabled the centre to levy tax on interstate movement of goods. I've just got 15 minutes, so I want to highlight a few points. There are powers of taxation divided between the centre and the states. The fundamental constitutional principle is that there is no overlapping of taxes. Either taxes are either in list 1 or they are in list 2. There is no overlapping of taxes. This is the theory. But in reality, the power to tax is so tempting that, and the power to cross that border is always so attractive, that we have reached a stage where the center has tried to go into the state area, state has gone into the center area, and that has given to the most unfortunate concept of aspect theory in our constitution. This is not the time, but it's my humble opinion that there is no place for aspect theory. Either it's a central tax or it's a state tax. You can't have an aspect theory, which is a topic for some other day. So one problem with fiscal federalism was, in many cases, the center would tax, say for example, particularly in computer software, they will say it's a service, tax it. The same thing state will tax, saying software is goods, therefore state will tax it. The unfortunate consequence was, between the tussle between the center and the states, India lost. If you have 12% service tax levy and 16% service tax levy and 12% sales tax levy, put together the taxation comes to 28%, and which makes our goods uncompetitive. It's no longer worthwhile to make in India, and it's no accident that these things have gone up. If huge imports from China continue, it was 100 billion, today it's $137 billion goods are imported from China. In 8 critical sectors, the main supplier of goods is China, because it is not worthwhile making in India on a thing. So this kind of multiple taxation has led to problems. The other danger which Mr. Vaidyanathan highlighted was the cess. All Finance Commission says that there is a union pool from which it is distributed to the states. Justice Chandrachud, in 2 or 3 judgments, he has given quite a few judgments, discuss a lot on fiscal federalism, competitive federalism, contestative federalism, uncooperative federalism. All this as part of our now jurisprudence. But he makes an important point. The taxing entries are the latter part of every list. So entry 1 to 45 are the general subjects, agriculture, public health, etc. Then you have the taxes. Similarly, in the center you have entry 1 to 81, all general topics, trade and commerce, reserve bank, company law, etc. And then you have the taxes. Now, the first part are your assignments of your legislative functions. What are the fields of legislation for the center? What are the fields of legislation for the states? And the Supreme Court, Justice Chandrachud makes an important point, that if this legislative function is to be meaningful, it must be accompanied by the devolution of appropriate financial powers. States have 2 methods of raising finances, either borrowing or by taxes. So whatever they can tax is there, but since a large number of subjects have gone to the center, they must get some money from the center as well. One disturbing factor, which is assuming dangerous proportions, I don't know, unless we go back it may lead to further problems. Just see the statistics. Now, any surcharge and any cess need not be distributed to the states. And you will find all these surcharges and cesses are levied in the Finance Act of a particular year. There have been very good cesses. For example, you had the diesel cess, which led to the building of the Golden Quadrilateral. Major General Kanduri was the architect, and we had a brilliant network of highways all across the country, only with the help of cess on diesel and petrol. That what happened during Prime Minister Vajpayee's government. But in many, many cases, these cesses are levied, but they are never used for that purpose. This is education cess. If you take the education cess and if you just dig deep, you will find that very little is gone for education, it has gone to the general pool. Section 12B of the Excise Act talks consumer welfare cess. Now we have got a system of unjust enrichment. If I passed on a duty and that duty is wrongly collected, they will not give it back to me. They will say you passed it on to X and Y, so why should you get it back? Let it go to the consumer welfare cess. I have not seen any case where consumer welfare cess has been utilized. But the point I am making is, there is an increasing tendency to levy cess and surcharge which is retained by the center and not given to the states, and that is leading to some kind of conflict. In 2012, 7% of the total revenue of the cess was 7% total revenue was through cess and surcharges. 2015 it became 9%, and in 2023 it has become 16%. So 1/6 of the money now collected by the center is not distributed to the states. To what extent it can go on is a matter of serious doubt, but I think today when we are discussing of federalism or concurrent list constitutionalism, I think constitutionalism requires that sufficient money is given to the states to enable them to discharge their functions. That's the point I am making. Now, just two important judgments which have come recently, which again have, especially the mineral judgment, has led to its own problems. In the mineral judgment, I had occasion to appear for the private parties. Both the mineral judgment and the liquor judgment overturned earlier rulings of 1990. So judgments of 7 judges given in 1990 were declared to be bad in 2025 or 2024. So after 34 years, the law was reversed. Now in the minerals matter, mining is, the regulation of mines is in the central list. They can regulate mineral activities. But the states have got the duty collected. So in the under the Mines Mineral Development Regulation Act, whatever royalty is collected, whatever cess is collected, is distributed, completely goes to the state. So today, if say a cement company is going to take mine and pay royalty, that challan is collected by the collector and takes to the state. So we argue that the royalty which is being levied is actually, though a central levy, it's a fully state collection. There is no need to give states extra power to tax. Now, Justice Chandrachud speaking for the majority, Justice Nagaratna dissented, it was 8:1. Justice Chandrachud said that fiscal federalism requires the state to have independent powers of taxation. In the concurrent list, there is no tax. So where do they raise money? In the concurrent list, they can only raise fees. They can't levy tax. So he said that because of this skewed thing towards the center, let the states levy their own tax on entry 49. They can levy it without any limit. So today, entry 49, tax on land and buildings, can include tax on land in which there is minerals. So suppose you have got 20 acres of land. If it is just barren land, you can levy say 2 rupees an acre. But if that land contains minerals, then the tax can be depending on the quantity of minerals you extract. So now we are faced with the situation, and now the matter is coming up for a review matter now. We are paying, those of us, all of us indirectly ultimately use coal, iron ore is indirectly passed on to us, right? Whether whatever way to steel or fuel or whatever it passed on to us. Today you are paying royalty on the coal, and 7 or 8 states which have got coal deposits or limestone deposits are laying an additional tax, sometimes substantial, on the limestone again. Now, unfortunately, the minerals are not uniformly distributed. So if a state has control, say 80% of the coal or say 35% of the other minerals, if it levies a huge amount of tax, what happens? That is going to be a question of federalism in the context of fiscal. And what will happen is a practical reality today. The rate given by Tamil Nadu is extremely high, and technically speaking, whatever cement you make today will be completely uncompetitive compared to the other states. So this question of federalism becomes important because to what extent can you levy tax? The Supreme Court says once you have the power, then it's entire parliament legislation. I remember when I was a junior, in my school days, the highest income tax was 97.75%. I think Mr. Vaidyanathan would recollect that day. I was a student, he's slightly older than me. And Mr. Palkiwala had once mentioned, it is easier to earn 3 rupees and not pay tax than to earn 100 rupees and pay the tax. Because if you earn 100 rupees and pay 97.75, you are left with 2 rupees and 25 paise. It is better to earn 3 rupees and you are a richer person. So that's, of course, that's other big source of black money became because it became people automatically started evading tax. So there is no limit to what tax you can pay. So if tomorrow Tamil Nadu says I'm going to levy 100% tax on minerals, nobody can stop it. Now in the context of federalism, how far this can go, and it's indirectly based on concurrent list because it is not only between the center and the states, what about the competition amongst the states? That is also a point which we have to ascertain. Now let's come to liquor, and I'll just finish. Just tell me when I finish. How much time is it? I'll just mention about the liquor point. It's a very interesting case. Entry 8 of list 2 talks of intoxicating liquor. If you take entry 33 of the concurrent list, trade and commerce can be regulated by concurrent list. So your Essential Commodities Act, all your cement control order, your rationing, everything is under entry 33 of list 3. Now alcohol industry also is a regulated industry. What happened was, now it's intoxicating liquor. It's very interesting, intoxicating liquor, and we had a huge discussion of what is liquor, what is intoxicating, and so on. So it was a very, literally a spirited debate in the Supreme Court. Now this is interesting, especially as we come to 7 o'clock, it's better to speak of spirits. So and I'll conclude with that. Liquor is nothing but C2H5OH, ethyl alcohol. All of us have studied in college. Ethyl alcohol is basically liquor. Now it can come from corn, or it can come from molasses, and in some cases it comes from other vegetables, etc. in Europe. But today in India, 99% is molasses based. Now that molasses based liquor is rectified, and it's called rectified spirit, which is nothing but alcohol, ethyl alcohol of 95% purity. It can go up to 99%. That is intoxicating liquor because it can cause a phenomenon of intoxication, of inebriation. You can do it. So 95% you dilute it and you can do it. And in the course of our research, thanks to ChatGPT and Perplexity, we found that in Russia, certain vodkas have got 84% alcohol. Can you imagine what happens to your body? But that is, in India, not more than 43% is allowed. So that was the point. Now, there is something called denaturing. And why it is denaturing? Because it has got a tax aspect. Alcohol is the biggest source of income from states. And as we go to other things, GST, etc., is becoming more and more important. So alcohol is 300% duty. But alcohol is an extremely important raw material for various industries. Paints, varnishes, waxes, so many things. Alcohol is extremely important. So if you put 300% duty, industries will shut down, it will not work. Now what you do is you add what is called a denaturant. So if you add, and it's just 1%, 2%, if you add a denaturant, they say unfit for human consumption. So the controversy was, if you add a denaturant, it is unfit for human consumption. So the center said, state cannot touch it now, we will take it over. The short point was between the center and the state, by adding a denaturant, does it cease to be intoxicating liquor? What is the question of this issue of liquor? And we argued successfully. In this case, I appeared for state of UP and state of Tamil Nadu, and we succeeded by saying that as far as denaturant is concerned, there is a schedule of denaturants. If it has to go for varnish, you have to add this chemical. If you have to go for this, you have to add this chemical. Now, why do people die in these huge tragedies? If the denaturant is methyl alcohol, which is CH3OH, it leads to blindness and death. All other denaturants, you can drink the alcohol, you will get nauseated, you will vomit, but you will not die. But if it is denaturant, so what happens is when this denatured spirit is cleared from the factory, it is sometimes siphoned off by the illegal persons, and the poor man doesn't know that he is selling something with methyl alcohol, and that's how you have liquor tragedies coming from time to time. So finally the Supreme Court said, again on the basis of state taxation, where does the state collect tax? And what we had argued was, I said that, let's say this is 100 liters of alcohol. This is rectified spirit. If I clear 90 liters to IMFL to make vodka, whiskey, rum, gin, the 4 brands, I pay 300% duty. Same 10 liters, I just put 2 drops, 0.1% of a denaturant, it becomes denatured spirit, I pay only 16% duty. On one I pay 300, one I pay 16. So I said that till the goods leave the factory, everything is intoxicating. By just adding that, you cannot take it away from the state's powers. So it's a big victory for the states. Now every alcohol, including denatured, natured, is completely coming within the state's powers. And that was a big source of victory for the states, because they could not levy denaturing fee, they could not levy denaturing taxes and so on. Why is this relevant in the concept of concurrent list? And I'll conclude. This is relevant because the 101st Amendment has levied GST. The biggest source of power of the states, sales tax, is gone. You surrendered it, and as Mr. Vaidyanathan rightly pointed out, it is a tribute to our Parliament and our state governments from 1st July 2017 till 25th April 2025. All the states and the centre have uniformly cooperated in the GST Council. It's a phenomenal thing which we should not take for granted. But Justice Chandrachud has issued a slight warning. The unique feature of GST, it is a concurrent tax. There was a debate. No list 1, 2, 3 refers to GST. It is only referred to in 246A. Parliament and the states can levy a tax on goods and services. So this is one tax which both the states and the centre can levy. Now the argument of the union was that if the GST Council recommends something, then the state's power is gone. That concurrent power is gone. We argued that no, 246A say that the centre and the states can levy tax. Today, ladies and gentlemen, technically speaking, if Tamil Nadu or Maharashtra or something wants to have a separate amendment and their own GST, nobody can stop it. Technically speaking. And why do I say this? That's why I said it's a great compliment to all of us that we are still so united in the most important things. That's why great strength that any kind of attack we can still withstand and we can meet anybody. That's my personal belief. But coming to this judgment of Chandrachud, and I'll finish. He said, and this is very important, GST is a concurrent tax. It's like a list 3 tax. What is the GST Council? 1/3 the voting power goes to the centre and remaining goes to the states. So state has got overwhelming power. 28 states have 2/3 the power and one central government has 1/3 the power, 33% power. So technically speaking, they can virtually veto any law which the state can make under the GST Council. But what the Supreme Court held was, GST Council's power does not take away the state legislature's power to make law. State legislature is sovereign, it is supreme. Even today, the state legislature can make a law overriding what the GST Council does. But they put a caveat, whatever GST Council does says is binding on all subordinate legislations. So no notification, no regulation, no rule can be contrary to the GST Council mandate, but each state's legislative power is still supreme. And that's where he said there is cooperative federalism, there is contestative federalism, and there is uncontestative federalism. And he says this opposition between the center and the states is a froth which is useful for democracy. And there's a wonderful article in Yale Law Journal on which he has also based this topic. And finally, I'll conclude with what Mr. Vaidyanathan said. He mentioned about the Panchayat Raj. When I was preparing for this lecture, I said we talk of federalism in the context of center and the states. We should also talk of an intra-state federalism, the state government and the panchayats and the municipality. That also has to be a joint effort. You know, The Economist had a very good article on India about 3 months ago. Very interesting. I was in the US sometime back during Christmas, and while discussing with people, I found that the county where my relative lives, that county decides the schools, decides the police, decides everything. The mayor of the town is a very, very important person. Today we don't know whether there is a mayor or not a mayor in the Tamil Nadu government, because it has no power at all, except wearing a robe, and you can get one color photo in the Hindu once a year. There is no power. But the Economist makes a point that only 8% of the salary government employees are at the federal level, more than 90% are at the county, district and state levels. In India, it is just the reverse. As he mentioned, Schedule 11 under 243G and Schedule 12 under 243W are dead letters. I think if they can really devolve powers on the panchayats and municipalities, it will make the panchayats and municipalities strong, that will make the state strong, and eventually that will make India strong. Because ultimately, what is India but a federation of states? If you have strong states, then the aggregate of all strong states will ultimately lead to a strong India. So with these thoughts, I thank the Shastra for inviting me here. And as far as concurrent list is concerned, I would submit that whether it is list 1, list 2, list 3, if you put India first, then all the problem is solved. Like the concluding part of this judgment of the governor, Justice Pardiwala quotes Ambedkar and says, you can have the best law, but if the people are vile, that constitution is of no use. You can have a bad constitution, but if you have good people running it, it will still be a good thing. We have a great constitution, and I'm sure that we should also all get together and become a strong nation. Thank you so much. We'll do it in the Q&A. That's the first question before the question answer. Yeah. Aspect theory is simple. It basically comes from Canada. Now, to explain the aspect theory, I'll give a simple example. You take, for example, leasing, hire purchase. Let's say you take a car on lease. All right? Now, leasing is taken to be a sale under the Constitution. Under Article 366(29), a lease is said to be deemed to be a sale. So only the state can tax. Now, to put it in simple terms, they levied service tax on leasing. I won't get into technicalities. How can you levy service tax? When I buy a car and I buy a lease, in my monthly EMI installments, it suffers a sales tax. How can I suffer service tax again on that? There I said, the government said no. On the interest component, there can be service tax. On the interest aspect, on the financing aspect, it will be a central subject. On this, it will be a state subject. A better example, which I argued and lost in the Bombay High Court, was on profession tax. Now, all entry 60 says a profession tax on trades, professions, trades and callings. As a lawyer, as a chartered accountant, as a professional, I pay profession tax. under the Constitution 276, profession tax cannot be more than 2,500 rupees. That is the limit. They levied profession tax on service tax on professions. So chartered accountants, lawyers don't have to pay service tax, but the client pays it on the reverse charge. But let's say I'm a chartered accountant. I am liable to pay profession tax under entry 60, not crossing 2,500. The chartered accountant also pays service tax. I said, when the tax on profession is in state list, how can the center levy tax on the profession? That is the question. They brought in aspect theory. Under entry state subject, the moment you get a chartered accountant certificate, you pay profession tax. But if you render service as a chartered accountant, then you are paying service tax. With my limited intelligence, I have not understood the difference. I am carrying on profession. But he says that if you are a chartered accountant and even if you don't practice, you have to pay profession tax. But if you carry on profession, you pay service tax. The wonderful answer is in a judgment of Chinnappa Reddy in International Tourist Corporation. He says, if the state can levy profession tax, it can levy tax on a lawyer who's passed the law college but doesn't practice. It can levy profession tax on a lawyer who has passed law and also practices. Both profession tax can be levied. How can you make this aspect theory and say, on the service aspect, I will levy service tax, on the profession qualification, I will pay profession tax? According to me, it's an aberration. I hope sooner or later, this was laid down by Justice Venkatachalaya in the Federation of Hotels case, where they said you can levy tax on the expenditure tax and luxury tax. So when I go to a star hotel, in those days, anything above 1,000 rupees was a star hotel. You can imagine now where the price has gone. So if I spend 1,000 rupees, the state can levy the expenditure tax, the union can levy expenditure tax under entry 97. Since 1,000 rupees is a luxury, the state can levy luxury tax under entry 62. So to answer your question, how two taxes come? When you go to a star hotel, the state is levying tax on the luxury aspect. On the same 1,000 rupees, central government is levying tax on the expenditure aspect. Now I think you'll agree it's a wrong theory.
Thank you, sir, for that address on the political economy of federalism, which is as essential as the constitutionalism that animates it, and for also helping us understand that there is a connection between chemistry and the constitution, which between liquor and the constitution, which we will have to understand to appreciate the subject at hand.
That's why Mr. Datar is such an illustrious member of the bar.
So I think we are just in time for the question and answer session. So if there are questions, the microphone will be handed around. So I would request that our audience ask the panelists questions and confine ourselves to questions alone.
No. Can you please speak?
My name is Bala Subramanian, Mr. Arvind Datta student, BIM first batch. Okay. So the question is, Mr. Vaidyanathan made one point that as a principle of equity, the revenue should be shared with the local authorities. While I agree on the concept of equity, there's also the concept of efficiency. Now, I'm afraid the capacity building has to take place at the local authority level before they are allowed to spend. We also know the classic case of husbands being the panchayat president while wife is the elected president, all that. So that's a large amount of capacity shortage, I would say deficiency in terms of what contracts, the honesty and the integrity part. That's something we have to address. While that's one point. That's one part. Second part, now everybody says states should get more parks, but I have a devil's advocate. Now, look at the country as a totality. Now we have several states like, Kerala and all running large fiscal deficits. And we have borrowings. Like RBI is a lender of last resort, central government is a lender of the last resort. We'll have to appreciate that central government is an underwriter and we need to provide for that.
Sir, may I request you to ask your question?
The question is that I don't agree with this point that center shouldn't have this thing because it's a lender of last resort. That's my question. I drop it there.
No, Nobody is disputing center should have power to tax. In fact, center has a large list on which they can levy tax. Question is when you have certain agreement based on which the GST was evolved, and if you then levy cesses and surcharges which are not thereafter shared, then it is a breach of the very faith and trust based on which the unanimity was arrived at for the purpose of pulling everybody's power of taxation and vesting it in one central authority. Oh. See, as Mr. Zafar was pointing out, cesses, when they are levied for a particular purpose and used for that purpose, nobody will quarrel. Quadrilateral roads were arrived at. Education cess, now it was intended when right to education was made a part of the constitution, and then education cess was carved out. Today what is happening? A huge amount is being collected but is not really being used for that purpose. Therefore, these are aspects where states have grievances, and we need to have a harmonious understanding between the central and states. I think the problem is today you have one particular government. In the center, another party ruling in state. There are persons who have a feeling that this party which is ruling in this state is not doing a good job, and the party which is ruling in center is doing a good job. And therefore you start supporting the powers of the center. Tomorrow the party may change. What happens? Therefore, please don't look at constitutional issues from the point of view of who is ruling today in the center and who is ruling today in the state. That's a very, very wrong approach.
Good evening. I am Lakshmi Narayanan. My question is to Mr. Arghya Sen. So you were telling about, I think whatever your presentation is based on, the current political context of a very strong central government, which has got a very good majority in the last 10 years. But don't you think it would be different when you look at the context of the 1990s and the 2000s, when India was run by government through coalition, where you had a situation where the regional parties were very demanding with the central government? Would the situation be different? How do you see that?
So I
Thank you.
echo the thought that Mr. Vaidyanathan just had, is that we shouldn't look at constitutional interpretation on the basis of either who is in power or the type of government that is in power. Because the fact is, you're absolutely right, that the entire system of India's governance is based on a system of checks and balances. So if there is a general sentiment that constitutional law and law abhors a vacuum. So if there is a strong center, then in that case, as in, we will have to ensure that the state governments are also in a position that they can carry on their actions without being completely trampled by the center. So actually at this point of time, where there is a strong center for the last 10 years, that is exactly the time when the constitution and the constitutional provisions are being interpreted, like it was in this case of the state of Tamil Nadu, in a way that preserves this balance, so that the center's powers do not become even more. If we look at the case of the 1990s, when Chandrasekhar and Devegowda and Inder Gujral and so on were prime minister, and we had a center that was not as strong, then the constitution is flexible enough to be interpreted in a manner that the states do not ride roughshod over those areas where we need unity. So I think the constitutional provisions are such that they are capable of being interpreted in ways to suit the situation, but we should not do it keeping in mind which political party is in power, and we should not do it keeping in mind whether it is a government of A type or B type. We should do it keeping in mind how the overall balance of the system can be best preserved.
This is a slightly different question to this distinguished panel. We have seen about various cesses being levied and surcharges being levied but not utilized for that purpose. Would it be a good suggestion to see that Mr. Vaidyanathan said very rightly, justice delayed is justice denied. A lot of pendency in the courts are there. It's very, very alarming. So can there be a cess for a speedy justice? And this center and state can work together. There is no dearth of law jurists in the country. Law students have been there. Brilliant students are coming out every year after year. You have a standing example there on the panel there. So we have a lot of potential for reducing the pendency on the cases, sir. And that will unlock a lot of productive resources. Thank you, sir. Thank you.
So I'll only say one thing. I mean, this is a very interesting suggestion, but it certainly can be considered. But there's only one issue that I have with it, is that the problem as to why our courts are functioning slowly is really not a problem of allocation of sufficient money. So if you look at the central government's allocation under the centrally sponsored scheme on justice, the Ministry of Justice has allocated 7,900 crores. This was about maybe one year back in that financial year. So the amount is sufficient. What actually the problem was is that there is an inability of high courts to spend that amount. If you look at the utilization of that amount is 60%, and it's not the fault of the high courts. There's a very complicated mechanism by which this money comes from the union to the state. There has to be an allocation made by the state. So actually the issue is really not more money, which cess would solve. The issue is actually of efficient utilization. And just one more point, because you made this point on cess, I think, sir, to your point, the fact is that these cesses are not cesses in a technical sense, because the idea of what makes a cess and a tax is that the cess is for a specified purpose, has to be accounted for that purpose, has to be used for that purpose. And the fact is that the education cess, even our accounts don't say actually, even the CAG's accounts don't say actually where it is going. In fact, the CAG has given reports saying that this is not a cess. There was a Krishi Kalyan cess that had been used. This is just general purpose, because GST has happened, union revenue is coming down, so to bolster union revenue this is happening. So actually I think there is a constitutional case here to be fought as to whether this cess is actually a cess or these are all colorable exercises of power.
I want to respond. See, Section 138 was introduced in the Negotiable Instruments Act. Check bouncing. Overnight, 50 lakh cases were added to the criminal courts. Even today, 35 lakh cases are pending in regard to making it a criminal offense when the check bounces. This is a pure and simple case of a civil suit or for mediation. No, absolutely thoughtless legislation, according to me. What is the impact it will have on the courts was not assessed at all. No, one. Second, you talked about people have cartoons today in regard to Justice Pardiwala's judgment on governor's assent, fixing a time limit and saying who is giving this direction, courts which have huge pendency. Has anybody asked the governments, the legislatures, including the state legislature, why is it that there are only 14 judges per million when 30 years ago the recommendation was there should be 50 judges per million? I mean, these are the questions which need to be considered before we make this kind of criticism about judicial disposal.
I just wanted to tell you, many years ago, the Singapore government website said that law is the 7th biggest source of the Singapore GDP. I always felt that there is so much employment potential, so much contribution to the GDP if only we fill up the vacancies. Now, for example, if you go to consumer courts across the country, vacancies are huge. High Court 40% vacancies, tribunals vacancies. If all these vacancies are filled up, and the amount of work that will be generated also could be substantial. I think you are saying, pardon me? For? No. I'm saying that if you appoint more judges, more tribunal members and so on, that's where the disposal comes. Yes. No, one is the individual efficiency, one is the other thing. The other thing I'll tell you, people always talk about danger, delay. It's very easy. But if you go to the Supreme Court, it's one of the best websites, the National Judicial Grid, you will find that 74% cases are disposed of in the 5 years. It's only remaining 25% which get delayed. And as usual in the newspaper, like they said, no, if dog bites a man, it's not news, but if a man bites a dog, it becomes news. So suddenly you get a news that 30-year case is pending, something filed in 65. It's a real aberration. So I'm not saying that the judicial system is nice. And one more thing you remember, talk of arrears. Nobody says, out of the total arrears in the high courts, 53%, because we are doing the PIL for Lok Prahari matter in the Supreme Court, unfortunately Justice Kaul retired, 52.5% of the arrears in the high courts are only in 4 states, Calcutta, Madras, Allahabad and Bombay. No, 4 states. Bombay. Out of the cases pending in the district judiciary, 56% are only in 5 states. So it is completely skewed. So it's a larger problem which has to be addressed. I think Justice Nagamuthu would like to say something, please.
No, I got slightly different views. Sir, we are responsible to the litigant public and to the nation. We are still having suits of the year 1970, 1980, 2000 pending.
Second appeal, sir.
Are we not responsible? So we have to confess to this august audience that we are incapable. You can say this.
I won't say it's such a radical view that we are incapable. I'll tell you one more thing, just one point.
He can afford to say, but not you people. We are all you judges and we're lawyers, so don't worry.
No, fortunately, the people still have the confidence in the judiciary the most, compared to executive and legislature.
Absolutely.
Yes, there are problems, there are aberrations, but fortunately, why do they rush to court? They want justice. They are willing to wait and then get justice. Yes, we need to amend. We are still following the old systems of procedure. Unfortunately, we have not been able to, now mediation, when the Civil Procedure Code was amended, Section 89 was introduced. Conciliation and mediation should have been tried. How many judges in the original side are actually directing mandatory mediation? Even after the Commercial Courts Act has prescribed that you shall not file a suit before going in for mediation, every suit is filed in commercial court with an application for dispensing with mediation. Why? Because they need urgent retrieve order. This is a bogus claim. 90% of such applications should be rejected and they should be asked for go in for mediation. It's not being done because the judges, I think they need to, the mindset will have to be changed, they have to be retrained.
Correct. So let us also talk of the National Lok Adalat. National Lok Adalat that we are organizing. So in periodically we are doing it.
Mega Lok Adalat.
Mega Lok Adalat. What is happening actually? People may not know, but we know as to what is happening there. So we see in newspapers that today in the National Lok Adalat, this many number of cases were disposed of. Is it real? Sir, I tell you what is happening. So if National Lok Adalat or Indian Lok Adalat is arranged, the police people are asked to go and book all traffic cases. All these traffic cases on one single day, fine amount will be collected. We will say today, in this Madras alone, 25,000 cases were disposed of. What are those cases? How many civil suits you were able to dispose of? How many criminal cases you were able to dispose of? All these motor petty cases. We are telling, we are cheating the people by saying that we are conducting local violence, we are disposing of thousands and lakhs of cases. I don't know, people may not know, we know it. Thank you.
No, actually, the larger problem now that you mentioned, and in the light of what Orgo said, if one Supreme Court says governor has to finish in 3 months, there's a national uproar. Supreme Court is overreaching, you're not doing your constitutional duty. But nobody tells the government, where is the education cess going, where is this cess going? That nobody questions. If you question, then there is judicial overreach. That's also a short point. And one thing I leave it to the audience, in National Judicial Academy, Justice S.B. Sinha, one of our fine judges, he was telling us that, look, we talk of arrears in India. He said the danger is not the pending cases. In India, because access to justice is so poor, the number of filings is just 15 per 100,000. In a place like Singapore, it is 88 per 1 lakh. So just imagine if you go, then what our arrears will be. That's the point, you see.
Sorry. Want to say something?
Sorry. See, as Mr. Dattar and Mr. Vaidyanathan said, the vacancies will have to be filled up. Number one. Number two, meritorious candidates have got to be accommodated in the said post. Reservation can be applicable, but meritorious person from that reserved community has got to be appointed. Otherwise, it will be very difficult. Arrears will be there. When I was a lawyer, arrears were there. As a judge, arrears were there. Even now, arrears are there. And if you want to clear, meritorious person alone should be appointed.
I am G. Rajgopalan. I thought today's topic is on account of the governance issue, but we have not talked much about it. No, I just want, because, this is relevant because my friend also mentioned about the action of the governor.
But governor is not in the concurrent list.
That issue has some relevance because the governor is a representative of the central government. That is one thing. If you go by the definition in the constitution, the state legislature means the governor and the house. So therefore, the governor cannot be diverged from the house. Therefore, his resistance for any particular issue, bill, without going into the merits of that, cannot be said totally alien to the concept of legislature. Otherwise, there is no meaning in giving a definition that the governor, the legislature means the governor. Let us take, for example, take an extreme example for the purpose of deciding this his jurisdiction or power. Suppose state legislature tomorrow passes a law, including one of the state of districts in the state of Kerala and Tamil Nadu. Make that law. Everybody knows without jurisdiction, but they make that law and send it to the governor. What will be the role of the governor?
My answer is he has to still send it, pass it. It is for the aggrieved person to challenge it, because then your governor is sitting in the position of a court. He's getting into legislative competence. And one thing is there, the constitution, as Argo said, the silence of the constitution which he mentioned, silence is this constitution didn't put a time limit thinking governor will dispose of. You go to Article 254, the president has to give assent to state bills. That also is kept pending. Now, if the court doesn't step in, if the court steps in, why do you find fault with the court? And to answer your question, suppose tomorrow Tamil Nadu government passes a law saying each Tamil person in Madras will pay income tax. It is completely ultra virus. But can the governor say he can send the bill for reconsideration? Take the money bill. I'll ask a simple question. A money bill cannot include anything apart from finances. IBC was passed as a money bill. We challenged it. It's not for the president to say, look, this is not a money bill, I will not pass it. Once the money bill is sent back, it has to be passed.
Now, what is his role then?
Pardon me?
See, the adjudicatory power under the Constitution, particularly in regard to deciding constitutional issues on legislative competence, etc., is vested in the judiciary. It is not vested either in the executive or even in the governor as part of the house. That is the way the powers have been vested in the Constitution, and Constitution is supreme. It is not the legislature that is supreme. The constitutional supremacy will have to be respected, and the judiciary will adjudicate on whether the legislation is competent, valid or not, and not the governor.
And one more thing on reasonableness. Constitution expects no state to say Kerala is part of Tamil Nadu. Constitution expects no state government to levy income tax or levy custom duty. That is the expectation of that's part of perhaps what is constitutional morality, conventions, rules and so on. But you are testing a proposition to an extreme. The answer is, if that happens, the governor still can't say there is no competence, what he rightly said. It has to be passed. It's for the courts to decide, unfortunately.
I am Natarajan.
We'll have it off the floor due to paucity of time. Let me begin by thanking our evening's trinity of Senior Advocate C.S. Vaidyanathan, Senior Advocate Arvind Dattar and Dr. Orgo for giving us yet another intellectually enriching Logical Connect 2025, where we saw an interesting interplay of constitutional history, the role of the governors, the economy of fiscal federalism, the itemized evolution of power to tax, the nuanced understanding of the constitutional design, the text of the constitution, the context of its politics, and the subtext of its unraveling. The contestation and cooperative notions of sovereignty were also discussed. The constitutional canvas that is so suffused with the interpretative logic of the Supreme Court that we actively witness today is equally powered by the contributions of discussions of this type. Ultimately, we realize that the salience of what Justice Venkatachalaya said in the 2016 Law Day address applies even in the context of the union-state relations, that the rarest kind of power in our troubled world, it is said, is the one that is recognized but not exercised. With that in mind and our constitution at heart, let me also thank the organizers at Sastra University, the Chancellor Professor R. Sethuraman, Dr. S. Vaidya Subramaniam, and the supporting staff here at its Chennai campus for making Logical Connect a success as in every year. And let us all meet once again for Logical Connect's next edition in 2026. Thank you, and with that, may I request all of you to rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल वंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाता जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Have a photo.